welcome to BYJU'S Exam Prep. I'm Nivedita Raje, and this is the second video of last lab series. We started yesterday, and it seems to me that you guys enjoyed it a lot. Of course, it was worth enjoying. So much useful information about a very important law, Contracts Act, and we got to learn a lot, right? So that's what we are going to do today as well. Good evening, guys. Good evening. How are you all? Good evening. Good evening. So today our point of discussion will be criminal law. So I would be discussing what I feel is very important from your exam point of view, right? So let's discuss that. Hello, good evening, good evening. Everybody's here. Hi. So this is what we are going to discuss today, the weightage, of course, then culpable homicide, murder, theft, extortion, how common intention and common object is identified. They're both two separate things, by the way. General exceptions and the questions. Now, private defense is also important, right? Everybody knows that private defense is important, but I'm not discussing it in this session because I have discussed private defense already in one of my lectures that happened not very long time ago. The most important questions relating to criminal law, I discussed private defense in great detail. Like I discussed everything related to it, and I read a passage also, and the students were able to solve the passage without the passage. Actually, they were just able to solve the questions. That is great, right? That's how they got clarified with the concept. So you watch that along with this and you're sorted for criminal law. That's what I want to say. So private defense video that I have already released before, and this session should be enough for your criminal practice. Good evening, good evening. Okay, so yeah. Now, before we begin, you should know that there's a test series. Guys, there's not much time left. Students who are starting from the scratch, like they're just beginning their preparation, this can be a game changer for you. That's how important it is. Test series contains a lot of important stuff such as 45 mocks, 45 plus mocks. Actually, some of them are from CLAT, some of them are from other exams. Then there are more than 9,000 practice questions. You don't have to buy any single book. This टेस्ट सीरीज अलोन विल केटर टू ऑल योर नीड्स. कोई एपी भारद्वाज लेने की जरूरत नहीं, कोई एमपी जैन लेने की जरूरत नहीं, कोई किताब लेने की जरूरत नहीं है. ये टेस्ट सीरीज आपकी प्रैक्टिस के लिए बिल्कुल परफेक्ट है और इससे ज्यादा आपको बिल्कुल जरूरत नहीं है. इसी को खत्म कर लीजिए, इसी में आपका हो जाएगा सब कुछ, राइट? And with that, we are offering you All India Open Mock Tests, which gives you an opportunity to compete among thousands of aspirants, right? So you can actually determine the level of your preparation. And these test series and the exams, questions, everything have been curated keeping CLAT scheme in mind, and they have been curated by NLU students themselves. So they are the students who actually qualified CLAT. Now we know what consortium is looking for, obviously, right? This is the weightage of crimes, guys. So crime is usually always there. Like it might not be there in the sample paper that was released few days ago, the sample paper 2, but there was no core law. ठीक है, तो इससे पहले कि मैं आगे बढ़ूं, let me tell you something about it. The sample paper, it does not give you an idea of how the consortium thinks or what kind of questions are going to come. No, they do not give you any sort of prediction with regard to the exam. There is no information with regard to the exam. It's just so that you can practice. That's it. और इसका कोई ऑब्जेक्टिव नहीं है और इसका कोई भी एग्जाम पॉइंट ऑफ व्यू से लेकर, बट you can definitely look at the non-conventional passages that are there, right? And you can practice them and you can understand and you can gather that even newspapers can play a very important role because it's Not just core law that is important, information from other sources is equally important. तो अगर आप core laws पढ़ रहे हैं legal में, तो आप ये भी मान के चलिए कि सिर्फ constitution criminal contracts नहीं आएगा, कुछ newspaper से भी इधर उधर आ सकता है, और इसके लिए जरूरी है कि आप अपनी reading cannot determine what passages are coming. That's absolutely impossible. Right, you can definitely understand or sort of have an idea of what kind of topics can come from the core laws like constitution, criminal, but regarding the miscellaneous passages which are usually two in number in the actual exam, कहाँ से क्या पूछ ले वो लोग बिल्कुल अंदाजा नहीं रहता. तो इसके लिए जरूरी है that you work at your reading speed. You need to develop reading as a skill, and it should be a survival skill for the sake of this exam. That's how important it is. So read as much as you can, practice as many passages as you can, and if there is a passage that does not relate to a core law, or if there is a passage that you might not have read before, just treat it like any other unseen passage. ओके वो इतना डिफिकल्ट नहीं होगा. इनफैक्ट क्लैट सैंपल पेपर जो आया है उसका लीगल सेक्शन मैं उसे इजी टू मीडियम की कैटेगरी में रख रही हूँ, डिफिकल्ट नहीं है वो. ओके यप. So as you can see, criminal law is always there. If not two, but one passage would always be there from criminal. In 2020, there was a lot of criminal. In 2021, they reduced the number to just one. There was just one passage that came from general exceptions or general defenses. Then in 22, there was just one passage that was there on bigamy, right? So they do ask from criminal, but they stick to reasonable or more understandable topics which are not that complicated. Or if they would stick to a complicated topic, we are going to discuss it today. वैसे तो इतना डिफिकल्ट नहीं पूछते हैं वो लोग, लेकिन अगर पूछ लेते हैं बाय द वे गलती से, तो फिर उसके लिए भी हम तैयार हैं, क्योंकि आज के सेशन में हम वही कॉम्प्लिकेटेड टॉपिक्स डिस्कस करेंगे. बाकी तो सब तुम पढ़ के सॉल्व कर सकते हो. ये है थोड़ा सा कंफ्यूजिंग. मर्डर, कल्पेबल, होमिसाइड, थोड़ा सा जनरल एक्सेप्शन, कॉमन इंटेंशन, कॉमन ऑब्जेक्ट, they do create a simple, they do create confusion in young minds. Mansi, that's exactly what I'm doing. That's exactly what I'm doing. You know, you would learn a lot if you pay attention to what I say. ठीक है ना? तो वही तो कर रही हूँ मैं. Arbitration of contract. Arbitration of contract. There is no such thing as arbitration of contract. Okay, a contract may go for arbitration. Arbitration is, I did take a small session. I created a small short of arbitration. उसको देखा नहीं तुम लोगों ने? पढ़ा मैं सब देती हूँ, तुम लोग देखते नहीं हो. तुम लोगों को क्लास में लाइव पूछना होता है. इंफॉर्मेशन भले ही आपके डिस्पोजल पर हो. आप मुझसे पूछ रहे हैं कि लॉजिकल रीजनिंग करनी है कि नहीं. आर यू आस्किंग मी दैट? If you're asking me whether you have to do logical reasoning, yes, a big yes, capital YES. ठीक है, करनी है, बहुत अच्छे से करनी है. Arbitration and conciliation, that's the only third or alternate dispute mechanism that we have right now in our country, which is codified. We have a council for mediation also, but then we don't have a mediation law. Arbitration conciliation के लिए हमारे पास law है. तो arbitration में simple होता है कि instead of going to a court where there would be a judge and there would be a trial and proceedings and hearing of evidences, testimony, etc., which is a long process, you go to an appointed person who is called an arbitrator and you present him with what you want. Both parties would present their own sides, not their own side of story, but the remedy that they're seeking. And the arbitrator would consider the remedy, take a look at the contract or whatever the dispute nature is, and then decide whether the remedy should be given. Or if there is another remedy that is more appropriate, he'll give that. That remedy is called a reward, right? So even an arbitration reward can be challenged in an appeal in the High Court. Yep. Supreme Court actually. सबकी क्लास होगी बच्चे. Yes, so we were discussing this. Law of crimes has about 17% Weightage, you can always expect one passage at least from law of crimes. This time I'm expecting that there would be at least two passages from law of crimes. If not, ek to ho gayi. Okay. So law of crimes this time was a passage of bigamy, like I told you, and it was taken from I pleaders, and it was very easy. So if you understood the concept of bigamy, the passage was a cakewalk. Actually, that is exactly what happens in legal reasoning. If you understand core laws, the concepts that are important, the concepts that are taught to you in the classes, if you understand them well, the entire legal reasoning becomes a cakewalk for you. I get this a lot from my students that they are very good in legal in rather than in other subjects. But legal is still tricky. The I do give you a lot of information which is helpful. It gives you a legal aptitude, it makes you think like lawyers, लेकिन इसके कुछ नुकसान भी हैं. अब बच्चे क्या करते हैं, मैंने एक्स्ट्रा पढ़ा रखा है, मैंने तो पूरा टॉपिक पढ़ा दिया, ठीक है. अब जब बच्चे पैसेज पढ़ेंगे तो उसमें पूरा नहीं होता. Obviously, if they include every information, that passage won't be a passage anymore. It would be a book. They cannot give you a book in the exam, right? तो शॉर्ट पैसेज देते हैं, उसमें लिमिटेड इंफॉर्मेशन होती है. अब वो पैसेज से पूरी तरह से उसको पैसेज को पूरी तरह से कंसिडर ना करके अपनी इंफॉर्मेशन को यूज करने लगते हैं और क्वेश्चन को अपनी इंफॉर्मेशन के हिसाब से सॉल्व कर देते हैं. आइडियली जो आंसर वो कंक्लूड करते हैं वो सही होता है, लेकिन एग्जाम के हिसाब से वो सही नहीं होता क्योंकि एग्जाम पैसेज बेस्ड है और आपको आंसर वही करना है जो पैसेज में लिखा है. अगर आपकी दी हुई या फिर आपकी जो इंफॉर्मेशन है, आपकी जो नॉलेज है वो पैसेज में नहीं दे रखी, तो आप उस नॉलेज को यूज नहीं करेंगे, आप पैसेज की इंफॉर्मेशन को यूज करके आंसर कंक्लूड करेंगे. दैट्स व्हाट यू आर गोइंग टू डू. एलिट के लिए लीगल का लेवल कितना है? आई डोंट अंडरस्टैंड, आई एम नॉट श्योर. लीगल का लेवल मतलब इज इट हार्ड और मीडियम? डिपेंड्स ऑन द एग्जाम, कैन बी एनीथिंग. मुश्किल भी हो सकता है, आसान भी हो सकता है. Yes, I'm covering legal reasoning in this session. This is in fact the second lecture. I have already taught one topic of contracts. I covered about 70% of the Contracts Act in that session, the yesterday's session. Sometimes you get many correct, sometimes you get less correct. That's the way life works, Preeti. ऐसा तो होता ही है, ठीक है. तो कभी ज्यादा करेक्ट हो जाता है, कभी कम करेक्ट हो जाता है. अगर कम करेक्ट हुए तो देखो कमी क्या आ गई, क्यों कम करेक्ट हुए थे भाई? ज्यादा मुश्किल पैसेज आ गया, तुम फोकस नहीं कर पाए, क्या प्रॉब्लम क्या थी? अगर पहले ज्यादा ज्यादा सवाल सही हो गए और बाद में कम सवाल सही हुए तो मतलब तुमसे कुछ गलती हो गई होगी ऑब्वियसली. तो मैं कैसे बताऊं तुम्हें कि तुमसे क्या गलती हुई? तुम खुद आइडेंटिफाई करो क्या गलती हुई, क्यों गलत हो गए. पैसेज में फोकस नहीं था, पैसेज को समझ नहीं पाए, कंसेप्ट नहीं समझ पाए, क्वेश्चंस को नहीं समझ पाए, क्या परेशानी है? आइडेंटिफाई दैट प्रॉब्लम एंड डोंट रिपीट इट इन द नेक्स्ट मॉक और द टेस्ट. इट वोंट हैपन. Right. This series on YouTube, which has started from yesterday, 4-5 hours of self-study, will it be sufficient to qualify? Yes, Vinayak, it should be sufficient to qualify. I'm done with the syllabus, but confused on how to revise. Please help. You can revise through these sessions. You can revise through these sessions and mocks and tests. Take that test series that I'm propagating in every session of mine. उसे subscribe करो और करना शुरू करो. यही revision है. If one party not satisfied by the judgment of arbitrator, what can he do? He can go to the Supreme Court, challenge it. Now, any other revision going on by app or only on YouTube? Actually, the series is streaming on app and YouTube both simultaneously. Okay, so shall we begin? We should begin, right? वरना हम यही सब डिस्कस करते रह जाएंगे, पढ़ने का तो टाइम ही नहीं मिलेगा और आज का भी सेशन हो जाएगा फिर 2.5 घंटे का. So I don't want that. I don't want you guys to sit for more than 120 minutes. In fact, this session is going to be 90 minutes max. I'll try my best. Now, culpable homicide, a concept which confuses everyone. Okay, after so much clarification and after so much teaching, students still ask me, so ma'am, will this be culpable homicide? मतलब फिर मैं सोचती हूँ कि यार मैंने क्या पढ़ा है अगर बच्चा अभी भी ये पूछ रहा है तो. So my agenda for today's session is to clear culpable homicide once and for all. Okay. Anushri, yes. How to attempt paper, which section we should focus? You should start with GK first, and focusing should be there in all the sections. You cannot focus on one single section. Okay, yeah. Now, ready, everyone? Chalo, ठीक है. So we'll start with a story. Okay, we'll start with a story. Now, A and B were having dinner. Okay, A and B were having dinner. While the dinner conversation, an altercation hit. Right, there was an altercation between them, a disagreement, and they started fighting. Now the fighting got a little intense. And in the middle of that argument, in the middle of that heated conversation, A got angry and he threw a glass bowl towards B. Now that glass bowl hit B on his head, right? It hit B on his head. Now, suddenly, B felt a wave of something. He started losing his consciousness and he fell down. A immediately took him to the hospital. Turns out he was dead. He died just by that glass bowl hitting. Now, in this civilized world, in a world where we have law, codification, regulation, duties, etc., there are some things that just cannot be that cannot be overlooked, जिन्हें हम ignore नहीं कर सकते. And one of those things is killing of a human being, especially if that killing has been caused by one or another human being. So basically, culpable homicide, first deconstruct the word. Homicide means when one human being is killed by another human being. Like I told you, in a civilized setting, right, in a civilization, in a world where we have law, order, etc., we cannot allow people to kill other people. We have to create penalties, and these acts cannot be allowed to go unpunished. So if a person has been killed by another person, that person will be punished by law. Are you getting my point? That person will be punished by law. As soon as the law declares कि भाई, we cannot allow this to happen, what you did is not right, we are going to punish you. As soon as the law says this, that killing, the act of killing becomes punishable, and we call it culpable. So culpable means punishable. So when one human being kills another human being and that killing is not accepted by law, it is not right in the eyes of law, and law wants to punish it, that killing becomes culpable homicide. Clear or not? This much clear? This much clear? Everyone? Sneha, I am not sure how to answer this question. Can we stick to the session right now? Then we'll discuss your problem. कैसे solve करना है, कैसे crack करना है ना? पहले अभी session पे focus कर लेते हैं, फिर तुम्हारे जो personal problems है उनको deal कर लेंगे. इतना clear है? चलो. अच्छा. अब इसको change कर देते हैं. Let's change it. Right. Now, A, when he threw the ball, he knew, he had an idea that if I hit B on his head, he will die. Why? Because B had an injury when they were kids. B had an injury on his head, which caused a certain concussion. And if that concussion gets hit again, B will die 100%. And this is a knowledge that only A has, along with B's parents. Despite this knowledge, A hits B on the head. ठीक है, फिर से बोल देती हूँ मैं. बी के सर पे कंकशन है जो परमानेंट है. बचपन में चोट लगी थी तो उसके सर पे कंकशन आ गया था. और ए को ये बात पता है कि बेचारे के सर पे कंकशन है, और वही कंकशन पे अगर चोट लग गई तो ये मर जाएगा 100%. और ये जानते हुए भी कि इसके कंकशन पे अगर मैंने मारा तो ये मर जाएगा, वो जानते हुए भी उसने बॉल खींच के मारा. ग्लास का सेरो बोरोसिल का जो हैवी बॉल होता है वो फेंक के मारा उसने और उसी कंकशन पे वो लग गया, उसे थोड़ी सी वो इचकियां आई, थोड़ा सा चक्कर आया एंड ही वाज डेड विद इन सेकंड्स। अब यहाँ पे अगर एक आदमी को पता है कि भाई मेरी चोट लगाने से या मेरे इस एक्ट को करने से सामने वाले की डेथ हो सकती है और मैं फिर भी वो एक्ट कर देता हूं, तो ऑब्वियसली मेरा इंटेंशन क्या था कि वो मर जाए। अगर मुझे पता है कि अगर एक बच्चे को मैं ऊपर से फेंक दूंगी 7वें माले से या पहले ही माले से तो वो बच्चा बच नहीं पाएगा, मैं फिर भी उसे फेंक देती हूँ, तो मैं ऑब्वियसली बच्चे को मारना चाहती थी, राइट। तो जैसे ही किलिंग जो होती है वो इस इंटेंशन से होती है कि डेथ हो जाए। Sometimes in a situation, killing might be an accident or killing might not be the actual intention. But there are situations in which killing will be the intention. A person has acted in a way that other person dies. Death actually happens. तो जैसे ही एक act किया जाता है, an act is done with an intention to kill, and the killing is successful, that person actually dies, culpable homicide converts to murder. Okay, so as I'm using English and Hindi both, please don't interrupt me on my language. I cannot stay to a single language. It has to be English and Hindi. Right. So when I'm speaking in English, pay more attention. When I'm speaking in Hindi, you can just think about what I said. I'm not adding anything new when I'm speaking Hindi. I'm only translating what I already said. Okay. So is murder and culpable homicide are the same thing? You tell me. Will murder and culpable homicide will murder and culpable homicide mean the same thing? Homicide is a killing which is punishable. Okay, homicide is a killing which is punishable. I just said. What is murder? Is it a killing which is punishable? Yes or no? A very simple question. Will you get punished for killing somebody in murder? No, you won't be punished if you kill somebody with the intention to cause his death. Obviously, you would be punished. Yeah? What are you saying? Where is your head? Why is everybody saying no? क्या मैं समझा नहीं पा रही अपने आप को? अच्छा, तुम culpable homicide और murder के difference की बात कर रहे हो? Oh, yes, he'll be punished. He'll be punished. So if he's getting punished for a homicide, obviously it is culpable homicide, guys. Every murder is a culpable homicide. Every murder is a culpable homicide. I'm telling you one by one. Okay. So that is the difference between culpable homicide and murder. There are many killings which are punishable and they can be of different nature. For example, if a person is driving drunk on the road and he hits somebody and that person dies, it is his responsibility. But he did not want that man to die. He wasn't driving with an intention to kill. He was not playing a video game on road. It was an accident. But then a death happened. He got somebody killed. He disrupted somebody's family. He will be liable for it and he will be punished. But he will not be punished for murder. Why? Because there was not an intention to kill. A death happened because of his negligence. But since it was his negligence that caused the death, he will still be responsible, not for murder, death by negligence. That is also a culpable homicide. So wherever a killing happens, whether with intention or without intention, and that killing will be punished by law, you are liable for culpable homicide. Depending on what kind of culpable homicide it is, will determine the further offense. For example, if the culpable homicide is done with an intention to kill that person or with an intention to commit homicide, culpable homicide converts to murder. If a culpable homicide is done to a woman who is in a marriage which has not exceeded 7 years and she dies of unnatural circumstances and there is a proof that there was a dowry demand pressure on her soon before her death, it will be assumed, or it shall be assumed by the court, that her death was, or her husband or the husband's relatives will be responsible for her death. Now, this is also a homicide which is punishable. Here, culpable homicide is not murder. The lady might have committed suicide. There was not an intention to kill. But the circumstances still name this offense, and this is dowry death. This culpable homicide is called dowry death. If somebody is driving rashly on road and causes an accident, killing somebody, he will be responsible for a culpable homicide, which is called death by negligence. If I instigate somebody, provoke somebody, or torture somebody to an extent that they commit suicide, I am liable for their abetment of suicide. I am liable for abetment of their suicide. This is also a culpable homicide, which has a different name. Every killing in law, every homicide in law is culpable. Sorry, every homicide which is culpable or punishable is culpable homicide. Right? So it is like a genus. For example, let's say that I have a television. Okay, I have a television. Now this television is culpable homicide. The brands that come thereafter, Samsung, Sony, LG, TCL, etc. These brands are different offenses. Every brand, Samsung, चाहे Samsung ले लो, चाहे Sony ले लो, चाहे TCL ले लो, है सब टेलीविजन ही. राइट है सब टेलीविजन ही. इसी तरह से ये सारे ऑफेंसेस जिनमें डेथ हो जाती है किसी दूसरे की वजह से, चाहे वो गलती ही क्यों ना हो, ये सारे ऑफेंसेस कल्पेबल होमिसाइड ही होते हैं. इंग्रेडिएंट्स चेंज कर दो तो उनका नाम बदल जाता है. Did you get it? Murder is not the genus. Murder is the species. Culpable homicide is the genus. Murder is the species. Okay. So culpable homicide, basically it is defined in a very broad sense. Culpable homicide means whoever causes death by doing an act with the intention of causing death. This is the first statement is murder. So if somebody acts in order to cause death of somebody, the culpable homicide is called murder. Or if he has caused some bodily injuries which may result to death, he is liable for the death if it happens. Or if he commits, or he does an act which is likely to cause death and the act actually causes death, he is liable for that act also. Every act that causes death of somebody is called culpable homicide. Simple words. ठीक है? Yes. Now murder, again, when culpable homicide is committed with an intention to kill or an intention to cause death. First scenario, let's say this A and B, instead of A throwing a bowl at B, they start fighting in a balcony. Right, they were enjoying cool breeze in a balcony, but they start fighting. The argument gets so heated that A throws B off the first floor. Now, when B falls off the first floor, he dies. It usually doesn't happen, but he still dies. Will A be liable? Yes, A will be liable. But if you look at the circumstances, ordinarily a person would not die if he falls off the first floor balcony. The maximum that would happen is he might break some bones, but he will not die. B dies, nevertheless. A is definitely responsible because it is his act that has caused his death. But he will not be responsible for murder because the act doesn't manifest an intention to kill. इस act को देखकर समझ आ रहा है कि भाई ये बंदा बी को मारना नहीं चाहता था, वो गलती से मर गया किसी तरह से. ठीक है, इसी तरह से let's say they are fighting. B is constantly hitting A. Now in order to save himself, A pushes B. B loses his balance, stumbles and falls on a boulder, and that boulder hits his head. B dies on the spot. Now A did not do anything that could kill a person. He just pushed him. The happening or the outcome was a mere accident. A cannot be made liable for murder because there is no intention to kill. But let's say that A throws B off the 100th floor. 100वें माले से उसे धक्का दे दिया। अभी यहाँ पे क्या इंटेंशन हो सकता है? 100वें माले से गिर के कोई बच सकता है? मतलब शक्तिमान ही बच सकता है, और तो कोई नहीं बच सकता। ठीक है, या डीसी के कैरेक्टर्स, मार्वल के कैरेक्टर्स, ऑर्डिनरी ह्यूमन बीइंग तो नहीं बच सकता, राइट? अब यहाँ पे उसकी इंटेंशन मैनिफेस्ट हो रही है। भाई तुमने 100th फ्लोर से किसी को धक्का दे दिया है, तो तुम एक ही चीज चाहते थे, वो मर जाए आदमी, मर गया वो आदमी, तो मर्डरर। कोई मर्डर में मेंसरिया होना जरूरी है? मर्डर होता है, it seems that I have to repeat it again. I think you joined late. बच्चे, कल्पेबल होमिसाइड में ना इंटेंशन अगर जोड़ देते हैं, कल्पेबल होमिसाइड क्यों किया तुमने, तुमने डेथ क्यों कॉज करी, तुम्हारी हरकत से कोई आदमी मर गया, ठीक है, तो तुमने ये हरकत की ही क्यों? ए ने बी को मार दिया, ए से पूछा गया क्यों किया तुमने ऐसा, क्योंकि तुमने ऐसी हरकत की, आदमी मर गया। ए कहता है क्योंकि मैं चाहता था वो मर जाए, इसलिए मैंने ये हरकत की। अब यहाँ पे उसने बोल दिया कि उसने ये एक्ट किया इसलिए ताकि बी मर जाए, यहाँ पे उसका इंटेंशन था उसे मारने का, है ना? तो मेंसरिया क्राइम होता ही नहीं बिना मेंसरिया के, ठीक है? इंटेंशन का ही गेम है ये सारा। कल्पेबल होमिसाइड में डिफरेंट डिफरेंट इंटेंशन की वो होती है, डिग्रीज होती हैं। अगर डायरेक्ट इंटेंशन होती है तो वो मर्डर बन जाता है, इंटेंशन नहीं होती है तो वो कुछ और बन जाएगा, राइट? लेकिन इंटेंशन ही क्राइम को बनाती है। अगर कोई ऐसी चीज हो गई जिसमें इंटेंशन नहीं था लेकिन फिर भी क्राइम कमिट हो गया, तो फिर आप क्रिमिनल नहीं हो, क्योंकि इंटेंशन नहीं है, ठीक है? तो ये सवाल थोड़ा सा क्रिमिनल के कंसेप्ट को क्लियर करना जरूरी है। रीड द एलिमेंट्स ऑफ क्राइम, मेंस रिया के बिना क्राइम नहीं होता, ओके? What happens if a person tries to kill another person, that person doesn't die? He is liable for attempt. He is liable for attempt. That is what we call an attempt. If I wanted to do something, if I did an act which was meant to kill somebody, but that somebody had his stars aligned, he had his mother's prayers protecting him, and he somehow survives, I will still be liable for attempt because I did what I had to do, right? His saving is a miracle, but I will still be punished, not for an accomplished offense, but I will be liable for an attempt. If they do not accept that it was intention can be seen in circumstances. इंटेंशन को सर्कमस्टांसेस से प्रूव किया जा सकता है भैया। अभी क्या बताया मैंने तुम्हें, ए ने बी को 100th फ्लोर से धक्का दे दिया, कि इसमें से तुम्हें इंटेंशन नहीं नजर आ रही? अगर मैं एक आदमी को सर पे शूट कर दूं तो इसमें मेरी क्या इंटेंशन हो सकती है? क्या ही इंटेंशन हो सकती है, मतलब मैं क्या करना चाह रही थी? सोचने वाली बात है। सर्कमस्टांसेस से आदमी की इंटेंशन बिल्कुल क्लियर हो जाती है। क्या सर, मैंने उसे 100th फ्लोर से धक्का तो दे दिया, पर मैं उसे मारना नहीं चाहता था मैं लॉर्ड, मुझे नहीं पता था कि वो रबर का नहीं बना है। क्या, ऑब्वियसली, ठीक है? तो whenever there is a murder, the entire circumstances is examined, entire circumstances examined, कि भाई किस सर्कमस्टांस में हुआ मर्डर। क्या सर्कमस्टांस ऐसे थे कि मर्डर होना ही था, किसी और का हो जाता, या ये हरकत कोई और करता तो मर्डर हो जाता? अगर इसका जवाब यहाँ हाँ है कि भाई किसी कोई भी मर जाता, इतना भयंकर एक्ट था वो, तो ऑब्वियसली इंटेंशन था। Murder is not genre of culpable homicide. You are saying it the other way around, Sneha. It's the culpable homicide is the genre. It's the genus. Murder is the species. Okay, clear है? Everybody, does anybody want to still clarify the difference between murder and uh, culpable homicide? Anybody? I can still repeat it. We have time. Akshay, then a person would not be liable for murder. Let me clarify. We still have something to go. Clear? Good. Now, murder. Four kind of acts are called murder. In four acts, a person's intention is clear. And from the circumstance, you can gather the intention. So four circumstances, or in these four circumstances, if you cause death, the death is called a murder. And these four situations are given in section 300 of IPC. What is the first situation? The first, now listen to me very carefully. बहुत बहुत ध्यान से सुनना, ये बहुत important है. Krishna, which batch should you join, buddy? Why don't you talk to the counselors? You talk to the counselors and they'll tell you. You can join any batch that is releasing for 2024. But I would suggest you join the comprehensive batch, not the. Oh, we only have comprehensive batches. All culpable homicides are not murder, but all murders are culpable homicide. Very good, Priya, you got it. Yes, Priyanka Bhera. You want me to repeat? Culpable homicide is a killing which is punishable by law. If one person kills another person and law wants to punish him, that act is called culpable homicide. If a culpable homicide is done with an intention to kill, we call it murder. That is the difference. Okay. Now, I told you, फिर से, let me tell you this once again. That should take place. Oh, of course. किलिंग का क्या मतलब है बच्चे? किलिंग का मतलब ही डेथ है. होमिसाइड का मतलब है किलिंग. अगर डेथ नहीं होती है तो क्राइम इनकम्प्लीट रह जाता है, और उस इनकम्प्लीट क्राइम को हम अटेम्प्ट कहते हैं, है ना. जैसे इमेजिन करो, एक जेब कतरा है, एक पिक पॉकेट है, उसने किसी की जेब में हाथ डाला वॉलेट निकालने के लिए, जेब खाली थी. ठीक है, अब चोरी तो नहीं हुई क्योंकि जेब तो खाली थी, लेकिन कोशिश तो की उसने, इरादा तो उसका चोरी का था, तो उसको उसके इरादे के लिए पनिश किया जाएगा. अटेम्प्ट तो कर ही दिया ना उसने, उसे उसके अटेम्प्ट के लिए पनिश किया जाएगा. तो अगर क्राइम कंप्लीट नहीं हो पाता तो अटेम्प्ट के लिए पनिशमेंट मिलता है, राइट. और कल्पेबल होमिसाइड और मर्डर में डेथ होना जरूरी है, ऑफ कोर्स. नाउ there are four circumstances in which if the killing happens, the killing is called murder. What is the first circumstance? The first circumstance is when an act is done with an intention to kill. First, if the act clearly shows that a person did the act so that the other person could die, that act will be called a murder. First. Second, I'll give you an example. Now, let's say there's a person, or I will quote my friend. Many of you have heard this story before. I'll say it once again. So we had a friend. We were all going to Dehradun, right? And uh, he had this, I don't know what can I call you, but he had this weird, creepy habit of taking his head out from the train door or from the bogie door. That speed and the air that hits your face in that speed used to give him some kind of satisfaction, right? And he did it like very often. We were in an AC bogie and he was out to the door in the middle of the night and his head was out and he was making sounds, wow, wow, wow. He was doing all that. So he was enjoying that gush of wind or the rush of wind and he was feeling satisfied. Now it was pitch dark outside and the light near the door was also flickering, so he could not see a pole and the pole hit his head. Now, this was a very serious injury. Fortunately, we were about to reach Haridwar. We reached Haridwar. We took him to the hospital. Turns out he had a bad injury on his head. Now the doctor told us that he will heal right now, but there would be some memory losses. Some long-term memories will be lost. In addition to that, if he gets hit again here on this spot, he will die immediately. Think about another situation. Have you seen a movie in which the magicians, or let's talk about Harry Potter. Now, Harry Potter, Voldemort has his soul left everywhere in the world in pieces, and those pieces are called Horcruxes. Now, if Harry stabs the diary, a part of Voldemort's soul will die. Think of it. Think of this situation in an ordinary manner. If I stab a diary, what will happen? अगर मैं एक डायरी को स्टैब करती हूँ तो क्या होगा? What will happen if I stab a diary? In like in not in a Harry Potter universe, but in the actual universe. If you stab a diary or if I stab a diary, what will happen? Nothing. Exactly. Nothing would happen, yeah. Obviously, the diary will get damaged. इससे ज्यादा कुछ नहीं होगा. The maximum that would happen is the diary will be of no use, or it can be used even after that. Nothing would happen. But if I know that stabbing a diary will kill somebody because there is a piece of soul in that diary, and I actually stab that diary, what do you think my intention is? अगर एक मुझे पता है कि इस डायरी में किसी की जान है, ठीक है, हम एक्चुअल यूनिवर्स में है ही नहीं, हम एक फिक्शनल यूनिवर्स में जहाँ पे चीजों को हर्ट करो तो आदमी मर जाता है. तो अगर उस डायरी में मुझे पता है किसी का सोल वोल है और फिर मैं उसको खचाक से स्टैब कर देती हूँ, तो क्या इंटेंशन है मेरा? क्या क्यों किया मैंने वो डायरी स्टैब? ऑब्वियसली जब मुझे पता है कि उसमें किसी का सोल का पीस है और उसको हिट करने से उसका सोल खत्म हो जाएगा और इन टर्न वो आदमी भी मर जाएगा, तो मेरा इंटेंशन ही था उसे मारने का, तभी तो मैंने डायरी को स्टैब किया, राइट? तो ये मर्डर का सेकंड सर्कमस्टेंस है. अगर आप एक ऐसी जगह एक आदमी को चोट दे देते हैं जहां पे आपको पता है कि अगर उसे चोट लग गई तो वो मर जाएगा, तो आपके चोट मारने के पीछे सिर्फ एक ही रीजन हो सकता है, और वो रीजन है इंटेंशन टू किल. And if you do that, you will be liable for murder. I'll translate it into English. Let's say, Harry Potter example, stabbing a diary in an ordinary universe will not do anything. But if I know that that diary has a piece of soul in it, and stabbing it would cause somebody's death, and I still stab it, it means that I wanted that person to die, right? So let's come back to the ordinary universe. If I know that there is a weakness on somebody's body, it's a bodily injury, it is a weak spot on that person, and hitting on that weak spot will cause that person's death, and I hit on that spot and the person dies, I am liable for murder because I couldn't have done it with any other intention. But then there is a catch. I should have been aware of the weak spot. If I knew there is a weak spot and I hit on that weak spot, causing that person's death, I'm liable for murder. But if I didn't know about that weak spot, I had no idea, and I just hit him casually. I just stabbed the diary very casually. I just threw it in the water just to, make that person irritated because he was constantly fighting me over that diary. And I was like, why is he fighting over an ordinary diary? Little did I know that it has a soul piece in it. And I throw it in the river and the person drowns. Like without drowning in the river, he drowns, he suffocates. Right? So then I'm not liable for murder because there is not an intention to kill. But if I knew or if I had the knowledge about the spot, I use that knowledge, hit that weak spot, kill that person, I am a murderer. Clear? Actually, I think I already answered your question, buddy. Am I clear? Yes or no? Yes, I'm waiting for a lot of Y's and YES's. Hitting weak spot. Why do you ask something that I just said? Why do you want me to repeat necessarily? हिंदी में भी समझा दिया, इंग्लिश में भी समझा दिया. Everybody on the app and everybody on the YouTube. Clear, right? Very good, Vinayak. Very good. In private defense, section 100, only section 100. In any other kind of private offense, if you kill somebody, it is culpable homicide. But if there is a situation that exists in section 100, rape, murder, or grievous hurt, or acid attack, or kidnapping, abduction, wrongful confinement, etc., if one of that situation is satisfying and then you kill that person in self-defense, it is homicide. But it is not culpable homicide because law will not punish you. Actually, yes, in that situation, he'll be liable for culpable homicide. He'll be liable for culpable homicide. Good. You got it. You got it. Now, third situation. I hit a person with an iron rod on his head. Generally, 1-2 hits will not kill a person. But I hit him. Not just head, I kill him. I hit him. Or no, why should I be the culprit? Let's assume A hit somebody. So A hits B and he beats him badly, and he uses all kinds of instruments like hockey stick or phone, slippers, whatever that comes in his hand, whatever that comes to his mind, whatever is lying on the road, he uses it and hits him. Stones, brick, everything. Now that person lands in the hospital and he succumbs to his injury. He succumbs to his injury. Now enters an expert, post-mortem doctor, or the person who conducted the post-mortem. And in the post-mortem report, it is shown the expert opines and the expert certifies that the death is a result from the injuries, or that is the result of the injuries that were caused by A. Now the judge will ask you, were the injuries normal? The expert says, my lord, the injuries were not normal. They were very intense. They were serious. And the injuries were of such nature that they could have killed anybody in an ordinary course. They were so serious. ये मामूली चोट नहीं थी my lord. ये एक ऐसी चोट थी जो हत्या ही कर दे, जो जिससे जान चली ही जानी थी बेचारे की. बहुत भयंकर इंजरीज दी गई, मतलब मार मार के बेचारे का हलवा बना दिया है. कहाँ बच पाता वो. जैसे ही एक्सपर्ट ये बात कह देता है, चोट मारने वाला मर्डरर हो जाता है. In simple words, if somebody causes an injury which are of such nature that they will cause death in an ordinary scenario, or they are of such nature that they are very likely to cause death, and this statement or this declaration is given by an expert, then the person causing the injuries is liable for murder. Did you or did you not understand? What is the difference between attempt to murder and culpable homicide? बच्चे डेथ का डिफरेंस है यार, कैसे सवाल है ये. मैंने होमिसाइड में अभी तुमसे कहा कि डेथ कंपल्सरी है, और अटेम्प्ट टू मर्डर में डेथ नहीं हुई है ना. अटेम्प्ट टू मर्डर मतलब तुमने मारने की कोशिश की, बंदा मारा नहीं, उसके सितारे अच्छे थे, ये है अटेम्प्ट. कल्पेबल होमिसाइड मतलब डेथ हो गई और डेथ के लिए तुम्हें पनिश किया जा रहा है. एवरीबडी क्लियर? ठीक है, चलो. दिस इज द थर्ड सिचुएशन. Did your network go somewhere? I'll repeat. If a person inflicts some injuries, or a person is injured, right? Injury, I'm talking about injuries only, nothing else. Injuries. If a person is injured and the injuries are not normal, they are intense, serious injuries, and the expert certifies or declares that the injuries are not ordinary and that they can kill any person, and the person actually dies, the person causing the injuries will be liable for murder. हिंदी में भी समझ लो, अगर एक चोट लगाई तुमने एक इंसान को और एक्सपर्ट आकर बोलता है कि तुमने जो चोट लगाई है भैया वो ऑर्डिनरी नहीं है, ठीक है, तुमने सिंपल मार पिटाई नहीं करी कि एक थप्पड़ तुमने यहाँ मार दिया, एक थप्पड़ यहाँ मार दिया, उसको धक्का दे दिया, वो बेचारा गिर गया, उसके कपड़े गंदे हो गए, नहीं, तुमने मार मार के बेचारे की हड्डियां तोड़ दी हैं एकदम, वो अस्पताल में अपनी लाइफ एंड डेथ सिचुएशन में फंसा हुआ है, राइट. तो तुम्हारी इंजरीज नॉर्मल नहीं थी, तुमने जो किया वो नॉर्मल नहीं था, तो तुम्हें मर्डर के लिए पनिश किया जाना चाहिए, ये एक्सपर्ट के हिसाब से. क्योंकि तुमने जो इंजरीज इन्फ्लिक्ट की वो इतनी सीरियस थी कि किसी की भी डेथ हो जाती, और अगर डेथ हो गई तो तुम मर्डर के लिए लायबल हो। ओके, 1 second guys. Punishment for homicide and murder, what is the difference? See, every culpable homicide will amount to an offense. So for culpable homicide there is no specific punishment. Culpable homicide किसी और offense में convert होती ही है, right? तो culpable homicide या तो murder है या फिर murder नहीं है. तो culpable homicide not amounting to murder का तो punishment है, लेकिन culpable homicide individually किस कोई punishment नहीं है. ठीक है? I just if you understand the difference, you understand difference properly यार. ठीक है? तो अब मैं तुमसे पूछूं, ये तो तुमने ऐसा सवाल पूछ लिया कि मैम फोन का प्राइस 60,000 है बट आईफोन का प्राइस 80,000 है, क्या डिफरेंस है भाई इनमें? एक ही तो चीज है दोनों. अगर आप फोन कह के लोगे तो मैं आपको 60,000 में बेच दूंगा, लेकिन अगर आप आईफोन कह के लोगे तो मैं आपको 80,000 में बेचूंगा. ये this okay, so it doesn't happen. The phone and iPhone mean the same thing, the price would also be the same. So culpable homicide will get converted to other different offenses depending upon the degree of intention, right? There's no such thing as half murder. Where did you read it? If he doesn't die and goes to coma for lifetime, very good question. It is attempt to murder and he'll be punished. If he wanted to murder somebody, see, the outcome is not really, there's no punishment for coma specifically. So what is it that you wanted to? If your injuries were of such nature that they could cause death, then you would be liable for murder. But if murder doesn't happen, but the injuries land somebody in a permanent vegetative state or causes a permanent injury, then you would be liable for attempt to murder. लेकिन अगर नॉर्मल इंजरी में कोई कोमा में चला गया तो फिर तुम्हें ग्रीवियस हर्ट का पनिशमेंट मिलेगा, राइट? Grievous hurt is hurting somebody intensely. That is grievous hurt. कर रखी हो और उसे पता ना हो कि वो क्या कर रहा है तो उसे कोई फर्क नहीं पड़ता, उसे कोई फर्क नहीं पड़ता. शराब पी रखी अगर तुमने जानबूझ के और तुमसे कुछ गलत हो जाता है तो भी तुम जिम्मेदार हो. हमें क्या मतलब तुमने शराब अपनी मर्जी से पी थी. ओके, या मूविंग ऑन. Now we are clear with 3 situations, right? The fourth situation, can I move over to that? I'll move over to the fourth situation only when everybody is clear with the concept. We only have 30 minutes remaining. We're still on murder and culpable homicide. I have a lot to finish. I'll discuss the fourth situation. We'll deal with the doubts later on. Now, the fourth situation is if a person does an act which is so imminently dangerous that it is going to kill somebody, it is going to cause death of somebody, and he still does that act, knowing that the act is extremely dangerous without any lawful justification, then also he is liable for the death, and he is liable for the death as a murderer. For example, if a person throws a bomb or a grenade in the middle of a crowd, he obviously knows that I'm throwing an explosive in the middle of a crowd. Somebody will die. Definitely, there's 100% possibility of a death. Now, I might not have specified a person that I want to kill, but a killing still happens nevertheless, and I will be liable for that killing. अगर मैं एक ऐसा एक्ट करती हूँ जो बहुत डेंजरस है, बहुत डेंजरस, और मुझे पता है कि उस डेंजरस एक्ट से किसी की डेथ हो ही जाएगी 100%, मैं फिर भी वो एक्ट कर देती हूँ, और उस एक्ट को करने के पीछे मेरे पास कोई रीजन नहीं है, कोई जस्टिफिकेशन नहीं है, तो अगर डेथ हो गई इस एक्ट को करके तो उस डेथ की जिम्मेदारी मेरी है एंड आई एम लायबल फॉर मर्डर. ओके, नाउ these are the ingredients of a murder. First, there should be an intention of causing death. Then there should be intention of causing such bodily injury. I already explained to you all this. Now, what is theft? What is theft? Try and understand it. Basically, if a person, something happens, something happened. No, nothing happened. Questions towards the end. I'm not reading any question. ठीक है, मैं कोई क्वेश्चन नहीं पढ़ रही हूँ. क्वेश्चन पढ़ती रह गई तो फिर तो सवाल कभी खत्म ही नहीं होंगे. मैं कुछ समझा ही पाऊंगी. सवाल एंड में पूछ लेना, पहले पढ़ लो. अभी चोरी क्या है? व्हाट इज थेफ्ट? नॉट एवरीथिंग इज थेफ्ट बाय द वे, राइट? सो इफ अ पर्सन टेक्स अवे a movable property, if a person takes away a movable property with a dishonest intention. Now that in dishonest intention means where when a person has an intention to cause a wrongful loss to somebody or wrongful gain to himself. अगर एक आदमी एक ऐसा फायदा लेना चाहता है जिसके लिए वो entitled नहीं है और दूसरे को एक ऐसा नुकसान देना चाहता है जो उसे नहीं देना चाहिए, तो अगर ये इंटेंशन होती है तो इस इंटेंशन को आईपीसी डिसऑनेस्ट डिक्लेयर करता है, राइट? सो इफ समबडी takes away or moves a property with a dishonest intention. Now a property that can be moved or a property that can be taken away is only a movable property. So in the nutshell, we gather that theft can only be committed of movable property. इमूवेबल प्रॉपर्टी का थेफ्ट नहीं हो सकता, सिर्फ मूवेबल प्रॉपर्टी की चोरी होती है, वो प्रॉपर्टी जो हिलाई जा सकती है, राइट? A person takes away a property or moves a property with a dishonest right with a dishonest intention without the consent of the person, then he is said to have committed theft. Got it? Sorry. Yes. तो अगर एक आदमी किसी और की प्रॉपर्टी को उठा ले जाता है एक डिसऑनेस्ट इंटेंशन के साथ, बिना उस आदमी की मर्जी के, बिना उस आदमी के कंसेंट के, तो हम कहेंगे कि उसने चोरी कर ली. ठीक है, तो इसके इंग्रेडिएंट सबसे पहले क्या है? अ पर्सन टेक्स अवे द प्रॉपर्टी, मतलब प्रॉपर्टी को हिलाना जरूरी है. यू वर ट्राइंग टू मूव द प्रॉपर्टी और यू वर मूविंग द प्रॉपर्टी फर्स्ट. Then the property has to be a movable property. Third, there has to be a dishonest intention. Then you have not taken the consent of the person, right? These are the ingredients of theft, and when a person does this, he is called a thief and he is punished under section 378. Not, but 378 defines theft. Right, so these are the ingredients. The offender had a dishonest intention to take that property. The property that was stolen or that was taken away has to be a movable property. The offender took the property out of the possession. अगर वो उठा के लेकर गया है या उसने प्रॉपर्टी मूव कर दी है तो उसने ओनर का या possessor का possession खत्म कर दिया. Basically the property has to be moved out of a person's possession. What does that mean? Possession means it's not just physical possession. Possession means I know where my property is. So if my phone is right in front of my eyes, or if it is in some other room, or if it is in some other corner of the house, but I know where it is. If I cannot see it right now, but I know where it is. It must be in my pocket, or it must be in my house, or it must be in the kitchen. I might have left it in the bathroom. Now this is what we call possession. Like, this is also what we call possession. But if I have no idea where my phone is, oh my god, where is my phone? Then it is out of my possession, right? So if a property is taken away, a movable property with a dishonest intention is taken away out of the possession of the person. Tree is not a movable property. Actually, the intention with which the trees are grown, that's a very deep concept that's not relevant. Trees are not considered to be movable property. Not all the time. Sometimes they are, sometimes they're not. Okay. Now, what is everybody understands was what theft is now. Now understand in extortion. Now, there is an element of theft. There's an in the element. Sorry, there's an element in theft. What is that element? A person is moving the property. I am moving the property. I'm making a conscious effort to take the property out of the possession. मतलब मेरी तरफ से मेहनत की है मैंने कि मैं प्रॉपर्टी के पास जाऊं, उसे उठाऊं और उसे लेकर चला जाऊं. यहाँ पे मैंने मेहनत की है, मेरा एक्ट इन्वॉल्व है, ठीक है. लेकिन एक्सटॉर्शन में बिल्कुल उल्टा हो जाता है. यहाँ पे क्या होता है? इफ a person threatens another person, threat can be anything, or intimidates him with anything, not right now, but something that he might do in future, intimidates him or scares him or deceitfully using some bad means persuades him to deliver a property, which can be any property, movable or immovable, then we call it extortion. अगर तुमने पुरानी, if you have seen मिथुन चक्रवर्ती's movies or old 70s movies, you must have seen, or even Basirpur for that matter, there is a guy who is going over to different shops and the shopkeepers are giving him money. Now this is not theft. Why? Because the property, money is also a property and it is a movable property, mind you. The property is being delivered, like he is not taking it away, but the shopkeeper himself is giving the money. Why is the shopkeeper doing it? Because he's scared of getting beaten up. He knows that if I don't give him money, he'll beat me or he'll thrash my shop or something. Now, this is deceitful. The consent has been manipulated. The person is scared. And in that scare or in that threat, he delivers his property himself to the offender. This act is called extortion. ठीक है. तो अगर ए बी की दुकान में घुस जाता है और उसका सामान उठा के भाग जाता है तो उसने चोरी की. लेकिन अगर ए बी के सामने आता है, कहता है कि मैं ना कल आके अपने दोस्तों के साथ तेरी हड्डियां पसलियां तोड़ दूंगा, और डर के मारे बी उसे अपना सामान खुद ही दे देता है, ले भाई ले जा, हड्डियां पसलियां मत तोड़ना, और बी मजे से सामान लेता है और चला जाता है. ये हुआ एक्सटॉर्शन. In the not really, not really. Robbery does not require a number of people. Robbery can be committed by a single person also. Yes, blackmail or fear. So robbery can be anything. Robbery actually can be theft also, can be extortion also. The elements would remain the same. In theft, the element is moving the property himself. The offender moves the property himself and takes it out of the possession with a dishonest intention. The property has to be movable. These are the ingredients of theft. In the offense of extortion, a person is not moving the property himself. He is in fact making it, delivered it to himself. He's scaring the person, deceitfully manipulating his consent and making sure that the property is given to him by that person. That is extortion. Now you add a little intensity in both these offenses. If theft is committed and while committing the theft or during theft, the offender creates a threat or the offender creates a circumstance in which the victim feels that I might be killed or that he will kill me or will hurt me, then the theft will amount to robbery. If theft is committed and a person who's being, who's being not robbed, he's being robbed right now. तो अगर चोरी ऐसे की जाती है या चोरी किसी या इस तरह से की जाती है कि सामने वाले को लगता है उसे चोट लग सकती है, उसकी डेथ हो सकती है, उस पर हमला हो सकता है, तो वो एक्सटॉर्शन में, वो रॉबरी में कन्वर्ट हो जाती है. तो अगर मैं चुपचाप चोरी करके भाग जाती हूँ तो चोरी है, लेकिन अगर मैं बंदूक दिखा के चोरी कर रही हूँ तो वो चोरी नहीं है, वो रॉबरी है. राइट। अब इन एलिमेंट्स वही है, सामान मुझे ही उठाना है, मुझे ही लेकर जाना है। एक्सटॉर्शन में भी यही है। अगर मैंने बंदूक दिखा के किसी को डरा के धमका के कि मैं उसकी जान ले लूंगा, या मैं उसको उसको ग्रीवियसली हर्ट करूंगा, या फिर उसकी प्रॉपर्टी को हर्ट करूंगा, उससे किसी क्लोज रिलेटिव को मार दूंगा, और इस डर में वो मुझे प्रॉपर्टी दे देता है, तो ये एक्सटॉर्शन कन्वर्टेड इनटू रॉबरी है। एग्जाम्पल से समझ लो, लेट्स से दैट ए वाज ड्राइविंग अ कार, right? A person comes in front of him, shows him the gun. Now, and he, while showing him the gun, he asks that person to come out of the car. He comes out of the car, his hands are raised. That person sits in the car, starts the engine, and runs away with the car. This is theft converted into robbery. In the next scenario, he shows or points gun towards him, asks him for the keys. The person delivers the keys himself. The person takes the keys, that offender takes the keys, sits in the car and goes away. This is extortion turned into robbery. Can robbery be a private offense? I'm not sure I understand your question. What are you even asking? प्राइवेट डिफेंस में कोई रॉबरी कर सकता है? कैसे कर सकता है यार? रॉबरी कैसे हो सकती है प्राइवेट? Robbery का main element है dishonest intention. The main element of robbery is dishonest intention. In both extortion and theft, the intention has to be dishonest. In private defense, you cannot have a dishonest intention. You are saving yourself. What kind of intention do you even have? The only intention is to save yourself, save your body, save your property. If you're asking me if somebody can defend themselves against robbery, yes, they can. In fact, if somebody is robbing them and to save themselves, they cause death of that robber, they will not be punished. Got it? Difference between extortion and robbery and okay. If it, if while committing the extortion, or while you know committing, or in order to commit extortion, a person creates an instant fear of death or grievous hurt. A person who is being extorted feels that if I deliver my property, he'll kill me instantly or he'll hurt me instantly. That extortion is called robbery. Okay. Similarly, in theft, if the offender creates a fear of death or grievous hurt, then it will be theft committed or converted into robbery. Extortion में जो fear होता है वो instant होता है, क्योंकि extortion generally property को deliver करवाने के लिए सामने वाले आदमी का physical presence जरूरी है, तभी तो वो property deliver करेगा. तो इसीलिए एक्सटॉर्शन में जो फियर होता है वो इंस्टेंट डेथ का या इंस्टेंट ग्रीवियस हर्ट का होता है. थेफ्ट में जरूरी नहीं है ऐसा हो सकता है चोर बंदूक लेकर घुसा लेकिन उसे कोई मिला ही नहीं थ्रेट करने को, वो फिर भी रॉबरी ही है. ठीक है, वो आर्म्ड थेफ्ट है. राइट, जिनको जिनको नहीं समझ आया, जस्ट वॉच द लेक्चर अगेन. These are the essentials of extortion. Should be an act which causes imminent damage or injury to a person. Must be done intentionally or deceitfully. Must tend to cause injury or harm to another person which he seeks interest. Unreasonable force should be shown through which a person seeks to take the property or any other valuable goods of another person or any document. Now, we have already read them. Common intention. What exactly is common intention? So, common intention basically is a rule of evidence, right? So, if there are a number of people involved in an offense and the participation is different, like some participated actively in the offense, but the others did not, but they were still a part of the offense. Now, the question comes, will you punish only the ones who participated, or will you also punish the ones who did not participate but still were there? The answer to this is yes, you will punish everyone. Why? Because they had a common intention. Okay, so there was this case, a very old case, King Emperor versus, keep forgetting the name, King of Emperors versus, if it comes to me, I'll tell you. So in this case, there were three people who went to rob a person. Now, the two of them were robbing the person while the third was standing outside guarding the door. After the robbery got committed, these three were arrested. The third person, who was acting as a security guard, pleaded that he did not participate in the robbery and hence should not be punished. The court said, fine, you did not participate in the robbery, but why were you even there? What motive did you have? You were there when the robbery got committed. You took your share of the loot. Your intention was to commit the robbery, even if you did not participate in it. And the fact that you were standing outside the door guarding it furthered that intention. You wanted the robbery to be committed easily, effortlessly, so that nobody barges in, nobody gets disturbed. The robbery can be committed easily. So obviously, the intention that you shared with the active participators is the same. And in that is why you will also be liable. This is what we call common intention. It is a rule of evidence that creates a legal fiction and imposes a liability on a person whose participation in the crime was not as much. ये है कॉमन इंटेंशन. अभी आते हैं कॉमन ऑब्जेक्ट. कॉमन ऑब्जेक्ट क्या होता है? कॉमन ऑब्जेक्ट इज बेसिकली a different scenario. Like common object is committed or an agenda of why the person did what he did, or the common goal of a group of people. So this common object has to be possessed by an unlawful assembly. What is an unlawful assembly? An assembly of 5 or more people whose common object is to commit a crime, or whose common object is to do something which law does not allow. अगर 5 से ज्यादा लोग इकट्ठा होते हैं कुछ ऐसा करने के लिए जिसकी परमिशन लॉ नहीं देता, तो ये असेंबली अनलॉफुल हो जाती है. ठीक है? So let's say that 7 people go to the bank to commit robbery. Now the object is commission of robbery. What does common object do? Common object also creates a legal fiction and it imposes a liability. Now, how does it impose a liability? Let's say that all these 7 people were armed. Obviously, if a robbery is getting committed, they would be armed. Element of death or instant hurt or whatever. Now, they were armed when they went to the bank. While the robbery was committed, one of them shot and the person died. One of the hostages was killed. The question is, will all be liable or just the person who shot the hostage be liable? Oh, very good. King Emperor versus Mehboob Shah. Very good. Everybody is liable. Yes, everybody is liable. Common object also creates a liability, but it creates a liability of an additional offense that happens. Common intention में एक ही offense हो रहा है और लोगों का participation अलग अलग है. किसी ने बहुत जोर शोर से participate किया, कोई बिल्कुल चुपचाप बैठा है, लेकिन वो आया इसी intention से कि लूट हो जाए, राइट? तो उसको पनिशमेंट मिलेगा. लेकिन अगर आप एक कॉमन ऑब्जेक्ट से, ये एक अनलॉफुल असेंबली एक गलत कॉमन ऑब्जेक्ट से आगे बढ़ी और उस कॉमन ऑब्जेक्ट को या फिर उस अनलॉफुल ऑब्जेक्ट को अचीव करते हुए किसी एक से एक और क्राइम कमिट हो गया, तो कॉमन ऑब्जेक्ट या अनलॉफुल असेंबली के रूल के हिसाब से सारे ही उस एडिशनल क्राइम के लिए रिस्पॉन्सिबल हो जाते हैं, प्रोवाइडेड वो एडिशनल क्राइम नेचुरल कंसीक्वेंस था कॉमन ऑब्जेक्ट का. मतलब सबको अंदाजा था कि इस ऑब्जेक्ट को अटेन करते हुए ये क्राइम हो सकता है, तो रॉबरी कमिट करते हुए डेथ हो सकती है, सबको पता है. तो जब सबको पता है और उसके बाद भी तुम चल निकले रॉबरी कमिट करने के लिए, तो भाई तुम भी उस डेथ के लिए लायबल हो, भले ही वो तुमने कॉज नहीं की, भले ही उसे कॉज करने के पीछे तुम्हारा जीरो इंटेंशन था, but the fact that you were part of that unlawful assembly while that death happened, you will be liable. So common object creates a liability for an additional offense that happens, while common intention creates liability on the basis of participation. Got it? Same punishment for all. They would be liable because they were part of the unlawful assembly. That's what law says. Why का कोई जवाब नहीं है. Why का कोई जवाब नहीं है. देखो ऐसा होता है, एक आदमी को अपने एक्शंस के लिए क्रिमिनल लॉ रिस्पॉन्सिबल डिक्लेयर करता है. ठीक है, तो अगर तुम्हें पता है कि काम गलत है और काम गलत है, तो उस गलत काम के पीछे एक और गलत काम हो सकता है. जैसे कि लेट्स से कहते हैं ना कि एक झूठ को छुपाने के लिए 100 झूठ बोलने पड़ते हैं. तो ये क्राइम इसी तरह से काम करता है. अगर एक क्राइम को करते हुए कोई और क्राइम हो जाता है, तो वो जो क्राइम हुआ उसके लिए तो रिस्पॉन्सिबिलिटी है ही, लेकिन जो दूसरा हुआ उसकी भी रिस्पॉन्सिबिलिटी तुम्हारी है, क्योंकि वो दूसरा वाला भी नहीं होता अगर तुम पहला वाला ना करते. फॉर एग्जाम्पल, ए ने घर जला दिया किसी का. अब उस घर में एक बी की बूढ़ी माँ रहती थी, वो भी जल गई भी. जिम्मेदारी है कि नहीं है? जो आदमी बर्न होकर मर गया उसकी जिम्मेदारी है कि नहीं है? तुम अगर घर ना जलाते तो ए की जो बी की जो मदर है वो भी नहीं मरती. तो तुम्हारे फर्स्ट क्राइम की वजह से ही सेकंड क्राइम कमिट हुआ है, और इसीलिए वो दोनों क्राइम्स तुम्हारी रिस्पॉन्सिबिलिटी है. अगर तुम लोग वो डेथ भी ना होती तो सारे ही रॉबर्स इसलिए लाइबल हैं. ये है वाई का जवाब. अगेन नेचुरल कंसीक्वेंस. अगर आप कुछ अननेचुरल कर देते हैं जिसका अंदाजा किसी को नहीं था कि भाई ये भी हो सकता है, तो नहीं लाइबिलिटी है. लाइबिलिटी तभी है जब आपको अंदाजा था कि हाँ ऐसा भी कुछ हो सकता है. रॉबरी के दौरान हर्ट और डेथ तो नॉर्मल है, लेकिन रेप नॉर्मल नहीं है. तो रेप की सजा सबको नहीं मिलेगी, लेकिन डेथ और ग्रीवियस हर्ट की मिल जाएगी, क्योंकि रॉबरी में एलिमेंट ही डेथ और इंस्टेंट हर्ट का होता है. आई जस्ट टोल्ड यू, फियर ऑफ डेथ एंड ग्रीवियस हर्ट रॉबरी में क्रिएट हो जाता है, चाहे वो थेफ्ट से निकली हो, चाहे वो एक्सटॉर्शन से निकली हो. तो डेथ और ग्रीवियस हर्ट अगर हो गया तो भी लाइबिलिटी तुम्हारी ही है. लेकिन रेप is a different offense altogether. It is not a consequence that is related. ठीक है, उसकी उसकी रिस्पॉन्सिबिलिटी तुम्हारी नहीं है. No, Ashi. If the assembly breaks and the assembly becomes of four, it is no longer an assembly. फिर वहां पे कॉमन इंटेंशन के बेसिस पे लाइबिलिटी क्रिएट की जाएगी. ठीक है, कॉमन ऑब्जेक्ट नहीं आ पाएगा यहाँ पे. Yogesh, I explained everything in English also. मतलब English only first, then I translated it. I'll explain again. See, common object basically ability of a crime that is committed while achieving the common object. Right. Common intention creates a liability when there is a difference in participation. That is what I was saying. So if an unlawful assembly goes to rob a bank and during the robbing somebody causes death of a hostage, all the members of the assembly are liable, because the common object was robbing and everybody had an idea that during robbing or during robbery somebody might die. So they are responsible if somebody dies, and all of them are responsible. Okay. Assembly, common object is a part of assembly only. Okay, only assembly may have a common object. That is where it comes from. Got it? Now let's do the general offenses. Oh, sorry, general exceptions. Very important. One of the questions was there in 2021. Okay, so if at all a question comes, it might be there from these topics only. We'll do all of them one by one. I'll explain all of them by examples. Try and understand. Mistake of fact. The situation is different, but the way you perceive it is absolutely different. And during that perception, a crime happens. Let's say that you're coming back from your coaching and you're sipping tea. You have a person sitting right in front of you and his face seems familiar. Okay, I'll deal with all the questions towards the end. Can you please allow me some time? I need to finish. Otherwise, I won't be able to finish. So what do you want me to do? Answer your questions or finish the topics? ये हाइपोथेसिस मैम, व्हाट इफ दैट, ये एंड में भी कर सकते हैं. अगर तुम कंसेप्ट को अच्छे से समझ गए हो तो अपने व्हाट इफ का आंसर तुम खुद भी दे सकते हो. ठीक है, नहीं दे पाओ तो बाद में पूछ लेना. Okay. Yes. Now, let's say that you are coming back from coaching, I guess, sipping tea. You see a person whose face is a little familiar, right? And you immediately take a picture, like, secretly, and you send it over your WhatsApp groups, asking everybody if they know this person. Suddenly, somebody replies, "Oh my God, his face is all over the town. He's a wanted person. He's a wanted dacoit." And you're like, "Oh my God, he's a wanted dacoit." And there's a reward on him. If you catch him dead or alive, he will be given 50,000 bucks. Now all you see is 50,000 rupees. "Oh my God, I'm going to get 50,000 rupees today." You are looking at him, and he catches a glimpse of you staring at him. He gets conscious, and he starts moving away, and you start moving with him. He is walking, you are walking behind him. He starts running, you are running behind him. Suddenly, you outrun him, and you sit on his back, and you call the police. "I have caught hold of this famous dacoit that is wanted. Please come and bring my 50,000 also." The police said, "Wait, hold on, let us come." The person comes, you're sitting on his back, and the person is shouting, "I am not who you think. Please, please let me go." You're not letting go because you have already dreamt of how you are going to spend those 50K. The police officer comes. As soon as the police officer comes, there's a radio announcement over the PCR which says, "Gabbar Singh caught in Ambala. Gabbar Singh caught in Ambala." Now, the person who you thought was Gabbar Singh, the person on whose back you are sitting, is obviously not Gabbar Singh, because in this situation, you have mistaken somebody for someone else, right? It was a mistake. This kind of mistake is called a mistake of fact. The situation was something, but you perceived something else entirely. Now, the offense that you have committed is wrongful restraint and hurt also, right? There is no buff. Really, there is a buff? Where did it start buffering from? Where did you hear what I said? The example? Did you not hear anything that I said? Oh, so you got the story, right? Now the court will actually examine the situation. He'll look at the face. He'll look at the face of that fake Gabbar Singh, and they would try to identify if somebody else could have made the same mistake. If somebody could have also thought that this person was Gabbar Singh, the resemblance was so uncanny that anybody could have made the same mistake, right? If the answer to this is yes, then you will not be punished. If anybody could have made the mistake, if anybody could have gotten to that conclusion that you did, then you are not liable. It was a simple mistake of fact. Got it? So there is a famous maxim: ignorantia facti doth excusat, ignorantia juris non excusat. Mistake of fact is excusable, but mistake of law is not excusable. If you do something and then you take the defense, "Oh, I did not know about the law." "Oh, is it not allowed to take somebody else's phone without their permission?" "I thought I could. I mean, I know the person since childhood. I thought I can just take away the phone and then start using it." Of course, you cannot do it. It's stealing. "But I didn't know it's stealing. I'm not a lawyer. I haven't studied IPC." Doesn't matter. You are still liable for stealing. Right. So that is what ignorance of law means. You are liable even if you don't know law. If you don't know what the meaning of stealing is, what is extortion, the police will do that for you. They'll determine the crime you have committed, but you will still be liable. But if there is a situation where you felt that you are justified by law to do something, the law has given you permission to do it. For example, Gabbar Singh, you sat on Gabbar Singh's back because there was a wanted poster of Gabbar Singh. The government had urged people of the district to find this man, and if they find him they would be given a reward. That's how dangerous he was. So obviously it was a civic duty, and you thought that you were only doing your civic duty, but it was a mistake, and this mistake will be excused by law. But the mistake has to be general in nature, could have been made by anybody, could have been made by any reasonable, prudent person. If that is a mistake or that is the nature of the mistake, you will not be punished. Mistake of law is not a defense anywhere, civil or criminal. It is not a defense anywhere. Everybody would take the same defense. Okay, take the example. Let's see. A is an officer of the court of justice being ordered by the court to arrest Y. After due inquiry, believing Z to be Y, arrest Z. He has committed no offense. Right? It was a mistake of fact. Now, judicial acts. What is judicial act? Judges cannot be punished for what they are doing. For example, the simple example of this would be, let's say, a trial court or a district judge or a sessions judge sentences somebody to death. The death goes in challenge, like the sentence of death is appealed in high court, and the high court reverses the judgment. The judge at the lower court will not be punished for what he did. Whatever a person does while acting as a judge, even if it is unfair or even if it is जुडिशियल कैपेसिटी में अगर आप एक्ट करते हैं या फिर जुडिशियल कैपेसिटी में अगर एक जज एक्ट करता है तब पनिशमेंट नहीं मिलता, मतलब जो वो कर रहा था वो एक जज की ड्यूटी थी, राइट वो वही कर रहा था जो उसकी ड्यूटी थी. ही वाज एक्टिंग एज अ जज. If a judge shoots a person in the middle of a court, he is not acting judiciously. He is acting like a criminal. He is acting like a normal person. Not clearly audible. Is it audible now? Good. Now we have accident. What exactly is accident? Sometimes when a person is doing something, even if it is lawful, he is very careful. He is not making a mistake. He's doing a lawful act in a lawful manner. But despite that, an accident happens. Right? So why does that happen? Do you remember or have you noticed that somebody in your family is conducting a puja for something, or have you noticed people doing puja for something because Shani is looking or giving them an evil eye, or Rahu is not sitting in the right house, or some other star is not sitting in the right house and it is causing all the problems. So even if you want to do right, a wrong thing happens. Right, so law actually considers this. Law understands that star alignment is very important. And even while doing something right, a wrong might happen. And it is nobody's fault. It is nobody's fault. So let's say A is driving. Okay, A is driving at a very reasonable speed. He's wearing seatbelt. He's not intoxicated. He's completely in his senses. He's not even listening to music. Suddenly there is a man who comes right in front of his car, or let's say there's a Neel guy that jumps right in front of his car. Now because he's at a reasonable speed, he stops immediately because a Neel guy has jumped on his car, destroying his engine and everything. Neel guy is an animal, by the way. Okay, it jumps on his car out of nowhere, which often happens. It's declared vermin in India. So in the middle of a highway, it jumps on the car, destroys the engine, the car stops in the middle of the road. There's a car that is coming right from behind at a very high speed and collide with Mr. A's car. Now this is an accident. It is nobody's fault. The animal came from nowhere. He was doing a right thing. वो कुछ गलत नहीं कर रहा था. वो एक आम आदमी की तरह गाड़ी चला रहा था, रीजनेबल स्पीड पे चला रहा था, लाइट जला के चला रहा था, सीट बेल्ट पहन के चला रहा था. Sorry. I should have water with me. Why do I always forget? Right? और सही करते हुए भी अगर कुछ गलत हो गया तो फिर उसकी गलती नहीं है. ठीक है, तुमने सुना भी होगा, मैम मैं सब चीज सही करता हूँ फिर भी गलती हो जाता है. तो यहाँ पे लॉ समझता है तुम्हारी मजबूरी और पनिशमेंट नहीं मिलता, इसी को एक्सीडेंट कहते हैं, राइट। For water, I would have to leave the room, which is not desirable at this point. Got it. So if a person is doing a right thing and he's doing it in the right manner, he's doing everything right. सही काम है, सही तरीका है, सही सोच है, intention भी सही है, काम भी सही है, तरीका भी सही है, सब कुछ lawful है. The intention is lawful, the work is lawful, the means or the procedure is lawful, everything is lawful. There is no illegal element, there is no bad intention, there is no malice whatsoever. The act is right, the intention is right, the procedure is right, everything is right from head to toe. But despite every right, all the checks and all the T's tried and all the I's dotted, a wrong despite that happens, then that wrong is nobody's fault. The liability of that accidental wrong can be attributed to no one. And this is the defense of accident. Nobody is liable in an accident. But then the person claiming the defense has to prove that he wasn't doing anything wrong. He was right absolutely. उसने कुछ भी गलत नहीं किया. ये प्रूफ करना पड़ता है. Okay? Now, absence of criminal intent. You already understand it. You already understand it. There are some people who get immunity from criminal activity. Those people are insane people, intoxicated people, and children. Now, some immunity is conditional, some immunity is absolute. So, for a child who is less than 7 years of age, law gives an absolute immunity. So, if a crime is committed by a child less than 7 years, that act is not a crime because there is no mens rea, there is no criminal intention. A child below 7 cannot form criminal intention, so he is not a criminal. But if a child is above 7 and below 12, he is mature enough to have an idea of what is wrong and what is right. ठीक है, इस एज पे बच्चा सही गलत की अंडरस्टैंडिंग रखने लगता है. Now in this situation, it will be examined whether a child knew what he was doing, and if the circumstances show that he had an idea of what he is doing, he understood what he was doing, he understood that what he was doing is contrary to law, it is prohibited by law, he understood the nature of his acts, he understood that it is forbidden by law and it will entail a penalty. Despite that he did it, he will not be treated like a child, he will be treated like a juvenile criminal. But all of this is proved through circumstances. Like I said, intention can be gathered from the circumstances. The way a person acts, आदमी किस तरह से एक्ट कर रहा है, इससे उसकी इंटेंशन क्लियर हो जाती है. अगर मैं ऐसे करूं तो मेरी इंटेंशन है कि मैं हाथ मिलाना चाहती हूँ, अगर मैं ऐसे करूं तो मेरी इंटेंशन है कि मैं हक करना चाहती हूँ, राइट. तो आदमी की कंडक्ट से, सर्कमस्टांसेस से उसकी इंटेंशन का पता लगाया जा सकता है. इसी तरह से अगर एक बच्चा 7 साल से ज्यादा लेकिन 12 साल से कम इस तरह से एक्ट करता है कि उसे पता था कि वो क्या कर रहा है, उसे पता था जो मैं कर रहा हूँ वो गलत है, कानूनन तौर पे प्रोहिबिटेड है, नेचर भी पता था उसे, और उसे पता था कि अगर मैं पकड़ा गया तो सजा वजा भी हो सकती है, लेकिन फिर भी वो करता है, तो वो एक क्रिमिनल है और उसे क्रिमिनल की तरह ही ट्रीट किया जाएगा. Between law of fact and accident, mistake of fact is a mistake. You have committed a crime in mistake of fact. मैंने तुम्हें एग्जाम्पल दिया था यहाँ पे, मिस्टेक ऑफ फैक्ट पे जाके बैठ गया है वो लड़का उसकी पीठ पे, ठीक है, तो वहां पे एक्टिव इन्वॉल्वमेंट होता है. क्राइम में, एक्सीडेंट में कोई क्राइम नहीं करता, लेकिन मिस्टेक ऑफ फैक्ट में क्राइम हो जाता है कमिट. एक्सीडेंट में कोई क्राइम नहीं होता, जो भी होता है वो गलती से हो जाता है, लेकिन मिस्टेक ऑफ फैक्ट में तुमने किया है, जो किया है गलती से किया लेकिन कर दिया. ठीक है. Over speeding is wrong. Excuse me. Who's over speeding? Khushi. Yeah, I'm taking care of my health. Don't worry. Yes. Did everybody understand the act of a child? So, a child who is below 7 is called doli in capex, incapable of forming an intention. So, no matter what he does, he will get an immunity, an absolute immunity. A child who is above 7 but below 12 is called doli capex. He may form an intention if he is mature enough. The level of his maturity will be determined through the conduct, through the circumstances. A child who is above 12 but below 18 is called a juvenile. And a child who is above 18 or a person who is above 18 is called an adult. Okay. Now we have act of a lunatic. If there is a person who in the fit of an insanity I told you can be anything, any mental disorder, any mental disease. In that fit of insanity, if he commits a crime, law will not punish him. Because an insane person does not understand the nature of his acts. He does not understand what he is doing, right? He does not understand that the act will be punished by law. So take this example. Let's say a person was in a fit of schizophrenia, and in that schizophrenic fit he got a hallucination that he was being attacked by soldiers. Now he wanted to save himself, right? A nurse was coming to give him his medication, but he was hallucinating. He thought a person is attacking him with a sword. So in order to save him, he attacked that person instead. He starts choking him. He, in his mind, he is choking his attacker, but in reality he is choking an innocent nurse. That nurse dies. This person is an insane person and he will not be punished because he doesn't understand what he's doing. But let's say that an insane person, despite the insanity, he gets a vision that, God wants me to sacrifice my eldest son. Now he creates a master plan. He takes his son in a very secretive manner, sacrifices him, buries all the evidence, and comes back home in a very hush hush manner, not telling anybody anything, not discussing anything with his wife. This was a real case. An insane person. He was also a schizophrenic. He believed that he could talk to people who did not exist. Now, once he got a premonition or something, a declaration from Allah that he should sacrifice his eldest son. So he took his son in the middle of the night and cut his head near the river and came back home and pretended like nothing happened. Now in this situation, the court said this act is not normal. A father killing his child is definitely not normal. This person is insane. But the way he committed the act, he was very secret about it. He took the child in the middle of the night. He killed him, buried all the evidences, and changed clothes before he came home and pretended like nothing happened. So he knew what he was doing. He understood the nature of his acts. He knew exactly what is going to happen if he tells the truth. He is liable, right? So if an insane person, while committing the act, the circumstances prove that the insane person also understood what he was doing. He knew the nature of his acts. He knew that the act was contrary to law. He knew that he would be punished for that act. He is liable. Yes. Now comes act of an intoxicated person. Intoxication. If a person is intoxicated and in that state of intoxication, he commits an offense. He is liable or he is not liable. In some situations, he is liable, but in some situations, he might not be liable. Law gives intoxication immunity or an immunity to an intoxicated person only in certain situations. The first is the inebriated state or the level of intoxication was so goddamn high that the person was absolutely out of his senses. The mental faculty had gone down the drains. मतलब मैं एक बार स्टेशन से बाहर निकलती हूँ, मैंने फुटपाथ पे देखा कि एक आदमी फुटपाथ पे लेटा हुआ है, उसने सर के नीचे पिलो की जगह चप्पल रख ली और एक डॉग आके उसके कान को लिक करने लगता है, उसके ईयर को, एंड ही स्माइलिंग। अब वो इतने नशे में था कि उसे पता ही नहीं कि मेरे साथ क्या हो रहा है और मैं कहाँ पड़ा हुआ हूँ। नशे में आदमी सीवर में गिर जाते हैं और सो जाते हैं। अब एक होश में आदमी अगर गटर में गिर जाए तो वो सो जाएगा नहीं, वो बाहर निकलेगा, खुद को साफ करेगा। लेकिन इंटॉक्सिकेटेड आदमी नहीं कर पाएगा, उसको वही आंख लग जाएगी उसकी। तो हम इस तरह के लेवल ऑफ इंटॉक्सिकेशन की बात कर रहे हैं। व्हेन वी टॉक अबाउट अ लेवल ऑफ इंटॉक्सिकेशन दैट इज exempted by law, we are talking about an inebriated state which makes a person crazy, close to insane, knows nothing, understands nothing, absolutely stupid. That is the level that we are talking about. The second is the intoxication or the substance or the psychedelic substance, whatever it is, booze, liquor, drugs, whatever it is, they have been or that has been administered to him without his knowledge or against his will. या तो उसकी नॉलेज के बिना उसे दे दिया गया है या फिर उसकी मर्जी के बिना, मर्जी के बिना या नॉलेज के बिना, तब ही वो इंटॉक्सिकेशन का डिफेंस ले सकता है. If he intakes alcohol himself, if he gets intoxicated on his own, persuasion is not against will, by the way. अगर किसी ने जबरदस्ती की एक आदमी से, प्लीज सर एक मेरे कहने से, सर प्लीज वन, प्लीज आई एम सेइंग सर प्लीज डोंट रिफ्यूज, and the person in persuasion consumes it, it is still voluntary. When I talk about involuntary, it has to be involuntary completely, right? Against the will or against the knowledge or without the knowledge. Like the substance was administered to him and he didn't even know what I'm taking. Or it was administered to him when his hands and legs were tired that way. Tied, not tired, tied. ठीक है? He's not insane, commit murder that time, then he plead for insanity. No, Akshay, that's a very good question. But while if he gets fits, and he's sometimes normal, he's sometimes insane, and he commits an offense when he was normal, then he cannot plead insanity. The insanity has to exist while the act was being committed. He has to prove that he was insane during the commission of the act. Otherwise, he will not get the defense. He'll be treated like an adult. ठीक है, तो बिना मर्जी के, जैसे कि this actually happened, I have a lot of stories to share. अब there was this friend of mine, we were celebrating Holi and everything, there were two stalls serving thandai. One thandai was spiked with marijuana, another was virgin thandai for women and children. Now this person took the non-alcoholic thandai and he placed it on the table and then went to dance, right? And one of the friends changed it, swapped the glasses for the adulterated one. Now he consumed it without the knowledge that I'm actually consuming drugs, without the knowledge. Now whatever he does after that will not be his liability because it has been administered to him without his knowledge. Okay. Now, yeah. Consent. Consent, I don't think, but I'll still explain. Consent has already been asked. So I'm not sure how consent is important, but we'll still discuss it. Now, consent basically is not defined in IPC, right? Consent is not defined in IPC. IPC actually tells you what will not be consent. Because if they tell you what is consent, the consent will become exhaustive. Right, it will be bound within the four corners. That is something that they don't want to do. So instead, they give it in a negative manner. They tell you what will not amount to consent. Rest everything is consent. So a consent given by a minor or a person below 12 years of age is not consent, right? Below 12 years of age. A person who is giving consent is intoxicated or insane, then it is not consent. A person who's giving consent in under a threat or a fear of injury or misconception of fact, then also it is not consent. So in these situations, if a person says yes, his yes will not be considered a yes. इंटॉक्सिकेटेड पर्सन से क्राइम कैसे दूसरे के क्या द्वारा कराया जाएगा? अगर एक आदमी ने एक इंटॉक्सिकेटेड आदमी से क्राइम करवा लिया तो फिर इंटॉक्सिकेशन, अगर इंटॉक्सिकेटेड आदमी डिफेंस ले सकता है तो वो ले लेगा, लेकिन जिस आदमी ने क्राइम करवाया है वो अबेटमेंट के लिए लायबल होगा। हर चीज का जवाब है, हर चीज के लिए ऑफेंस है। अगर मैं खुद क्राइम ना करके किसी और से करवा लेती हूँ क्राइम तो भी मैं लायबल हूँ, राइट। वाइकेरियस लायबिलिटी का कंसेप्ट क्राइम में भी आ जाता है, उसको अबेटमेंट कहते हैं। If sometimes, okay, if A plans to surprise his friends B and dresses up like a ghost and comes before the friend just to make him afraid, and suddenly B takes a sharp object and hits him, which results in death, will A be held liable? It will be a mistake of fact. No, it will be a mistake of fact. I already explained point number 1. Presence of absence of consent makes difference between not punishable acts and crime. Basically, what the first point is saying is, generally an act which might not be a crime, which ordinarily is not a crime, but if the consent is missing, it becomes a crime. So that's what it says. So for example, if a sexual intercourse is committed with an intoxicated person, now sexual intercourse is not a crime, but since it is committed with an intoxicated person, law will assume that he did not say yes or she did not say yes. His yes will not be a yes, and that sexual intercourse will become rape. That is what the first point says. Bailable property. What is bailable property exactly? A property who was bailed. Theft can be committed, or theft is committed from the possession. Theft is basically violation of possession. So even if I'm not the owner and I'm only leasing the property, or I've only bailed the property, then also it is theft. I was possessing it. The offense of theft talks nowhere about ownership. It is only talking about possession. Okay. Trifling acts. What is trifling acts or trivial acts? Basically, some people are oversensitive, right? And if something happens to them, which an ordinary person would never complain about, but they complain because they're oversensitive, then law will not consider their application and the offense will be called a trivial offense. The case is Mrs. Meena Mendes versus Khan. They got into an argument. Khan got irritated and he threw some papers. One of the paper caused paper cut on Meena's arm. Now, the offense of hurt is defined in IPC, but the intensity is not clarified. What I mean is, कितना hurt के लिए FIR कराई जा सकती है, ये क्लियर नहीं है. बस हर्ट की डेफिनेशन है, और हर्ट की डेफिनेशन के अकॉर्डिंग अगर कोई मेरे बाल भी खींच लेता है तो भी वो हर्ट ही है. सवाल ये है कि क्या मैं उसकी कंप्लेन करूंगी? तो अगर मैं उस हर्ट की भी कंप्लेन कर देती हूँ तो लॉ मुझे एंटरटेन नहीं करेगा, क्योंकि ये हर्ट नहीं है. दैट इज व्हाट ट्रिफल्स इज. The class is coming to an end only. This is the schedule, and now we have questions. Come on, let's do the questions now. Now I'll see your questions. Some passages of eight cases, it says consent of minor will be considered below 12. Sujan, below 12, consent of a person below 12 is no consent. Actually, there is a debate on it. Consent of a minor will be a consent, or consent of minor's consent is not considered to be consent, but they are in IPC, the age is mentioned. So the Supreme Court has clarified that, even a minor if says yes to something, it will not be considered to be yes. I'll actually hide my video. Don't worry. Done? Kavya, you need to focus on all parts. How to attempt paper? What do you mean how to attempt paper? Like, are you asking me the sequence in which the paper should be attempted? I think you should start with GK and then you choose any other section, ideally English, and then move over to legal, and then quant and then logical, or vice versa. And you need to focus on all parts. All the sections are important, not just legal or GK. You don't need to hear me right now, just focus on the passage. Can you all see the question? A was an aspirant who was preparing for civil services, very inspired by the life of a civil servant, but was very disheartened that the people of his locality do not give him the same respect. One day he falsely pretended to be a to be in the civil service, went to a jeweler, lent him a golden diamond jewelry, etc. Okay, read the question, answer it. What do you think your answer should be? It's absolutely correct. The answer is A. Very good. Yes, it is A. Moving on. Very good, guys. Very good. It's A. Absolutely. Are you answering for the second question? Are you answering the second question? It's not A, guys. It's D. Come on. A is not liable. He knew that the watch was counterfeit and he still bought it. B knew the watch to be counterfeit. He still bought it. A is not liable for cheating. So cheating is decepting somebody. If somebody is not decepted, if you lie to somebody and the person does not believe you, then you have not done any damage. It is D. Question number 3. Guys on the app, why aren't you answering? Kavya, Sajan, Akshay? Can you not see the questions? In the facts of a previous case, assuming A genuinely believes that the watches of brand X belong to brand Y and induces B to buy them, will your answer change? Now will your answer change? The answer will not change. Exactly. See, A genuinely believes that the watches of brand X belong to brand Y. He's not lying, he's not deceiving. He believes that he's selling a watch from a certain company. The answer still remains the same. Okay, he is not liable, it is D. Very good. Yes. Moving on, question number 4. A was in a dire need of money, asked his best friend Z to lend him some money, which he promises to return. Z refused, stating the financial condition of his family. A becomes furious by this and decides to lie about selling silk, etc. You answer. Okay, I'm getting the answers. Arya is the first to answer, I guess. She says A. Somebody, Hariom says D. Now everybody says A. It's A. Very good. A is liable for cheating. Yes, yes. The time of obtaining the money, he did not intend to deliver silk. Right? It is A. He is liable. So everybody knows that we have a mock test for ALET. It's an all India mock test. Everybody has to take it. Even if you're not sitting for ALET, I would still advise you to take the test. Practice ho jayegi अच्छे से. Okay? Do not leave it. Question number 5. Suppose in the facts of previous question, A genuinely intended to deliver silk at the time of making promise, but decided not to deliver it later on. Will he still be liable for cheating? It's a very good question. Okay, you might be surprised at the answer. See, at the time of committing the offense, the intention has to exist when the offense is being committed, not afterwards. So when I'm telling something to somebody, it depends कि मैं सच बोल रही हूँ कि झूठ बोल रही हूँ. When I'm saying something, what is the intention at that time? Did I want to lie or did I want to tell the truth? Was my intention to do or to do something which is honest? If my intention was not bad at the time when I was making the statement, then I'm not liable for anything. The correct answer to this is C. Only Inder answered right. And Cinderella, Inder. It is C. You did not read the passage properly. Now, passage number 2. Akshay was also right. Because the answer has to be simple. You don't. Why not D? Just follow the passage. पूरी पूरी कहानी जरूरी नहीं आंसर हो. A will not be liable for cheating because he intended to deliver the silk, but on account of certain facts he was unable to. How do you know there were certain facts? Question कौन से facts बता रहा है तुम्हें? ये तो तुमने अज्यूम कर लिया कि सर्टेन फैक्ट्स की वजह से उसने सोचा कि अब मैं डिलीवर नहीं करूंगा. हाउ डू यू अज्यूम दैट? द क्वेश्चन इज नॉट टेलिंग यू दैट. You cannot assume anything extra. That is why the answer is not D. Done? Okay, moving on. Oh, isn't Azad the sweetest? It seems like Akashvani, isn't it? Do you feel like you're sitting in the house of Big Boss? It's just voice. Done. This also? Really? Great. This passage is a little long. Done. Good. Good. Last. खुशी आप मुझसे सवाल पूछ रही हैं या फिर बता रही हैं मुझे मैम मैंने पढ़ा हुआ है आपसे डेफिनेशन इतने अच्छे से. Done. Good. Questions. Question number 1. चलो बता दो. Everybody now. Question number 1. Yes, this is the last passage. Which of the following best summarizes the position discussed in the passage? How to purchase BYJU'S mock test series Asmita? You go to the BYJU'S exam prep platform and then you subscribe to the series. I'm not sure about the process, but somebody in the team will tell you how to buy it. Or you can just, go to the platform and raise a request for a call. Somebody will call you and then you can purchase. They'll send you a link and everything. Everybody says D. Yes, D is absolutely right. Very good, yeah. Come on. क्या बात है, क्या बात है, शाबाश. Flower shop manager of A's business at the end of every month used to check accounts. When he was checking accounts, he saw that a customer named B has not cleared his dues for the entire month. A asked B not to sell anything today unless he clears all his dues and made a statement saying he's a man who always takes the flowers and pays nothing. And I have no opinion of his honesty. Okay, decide whether this is defamation. It's very easy. Super duper easy. That's so nice of you, Kushi. Thank you so much, sweetheart. Means a lot. Is this defamation? Okay, I have very less answering correct now. Is it A? It is not defamation. A is in the exception. Come on. It is not defamation, people. He's within the exception. It is not D. Question number 8. Renowned writer published several novels. Work of art and style is based on modern romanticism, often contain details of characters involved in romance. His new novel, widely criticized for such details about a married couple and their private life. B. Reading such novel belongs to orthodox family. Good faith makes a statement. A's novel is devoid of moral. He must be a man of weak character. Oh my God. Book is indecent. He must be a man of impurement. ज्यादा ही बक दिया उसने नहीं नहीं किताब के ऊपर इतना शोर अरे what am I saying? It always happens. People are just not easygoing in this country. It's actually A. It's A, yes. It's based on A's character so far as it appears in the books. It's not really, you know, you get what I'm trying to say. Now, question number 9. A writes a letter to B containing defamatory statement in Spanish, knowing well that B cannot read Spanish, but B's personal secretary does. B made his personal secretary read the defamatory letter and later filed a suit against A. What a good idea. You all can do it. Copy a bad statement from Google or translate Google or make Google translate something extremely bad in some unknown language, Hebrew or something like that, and then say it in front of a person you dislike. I'm going to do that. Is he liable for defamation? Yes, obviously he's liable for defamation because he knows that he won't be able to read the Spanish himself. He'll make somebody else do it, and other person is getting involved and he's getting to read all that bad comments. It is definitely defamation. Right. The last question of today. Last question of today. You're welcome, Kavya. Can you answer? She says it's A. Akshay also says it's A. You're right, it's A. Very good. It's A. D is liable for defamation because he made everybody believe that A was the thief. D is liable. Definitely liable. Okay. Now it's time for me to reappear. since this was the last question. So hello guys, I'm here. You performed great. The performance is amazing. Treat the passages just like that. Follow what is written in the passage. You need not use your personal information to solve the questions. That personal information should only be utilized to understand the passage more quickly. Right? So if you already understand what is written in the passage, you won't take as much time to decipher it. And that is the goal, that is the agenda. But at the end of the day, you have to stick to the passage. You cannot go away while answering, right? So that's it for today, guys. Thank you so much. I hope you enjoyed the session and learned a lot from it. Now this session, along with the one that I took on private defense, is enough for criminal law for the last minute preparation. ठीक है, अगर आप लास्ट मिनट प्रेपरेशन कर रहे हैं तो ये सेशन क्रिमिनल लॉ जो मैंने पढ़ाया था कुछ दिन पहले, प्राइवेट डिफेंस पढ़ाया था, उसमें वो भी देख लीजिए और आपका क्रिमिनल लॉ लास्ट मिनट के लिए इतना काफी है, इससे ज्यादा पढ़ने की जरूरत नहीं है। और बस पैसेज सॉल्विंग शुरू कर दो, बढ़िया तुम्हारा क्लैट निकलेगा, right? And you were with me throughout the session. It has been more than 120 minutes. Again an amazing, a very sincere effort. Hats off to your dedication, guys. Shabash, बहुत बहुत बढ़िया. May God bless you and your hard work. I sincerely hope and I pray that your hard work yields an amazing result and you get a college of your dreams, right? So take care, guys. Thank you so much. Good night, and I shall see you again very soon. Till then, everybody would take care. These sessions are going to be on a continuous basis every night at 9 p.m. whether for CLAT or ALET, राइट? तो इन सेशंस को लगातार अटेंड करिए. ये लास्ट लैब सीरीज आपके लास्ट मिनट प्रिपरेशन के लिए और रिवीजन के लिए बहुत जरूरी है. तो सेशन मिस नहीं करना है, कुछ भी हो जाए और कोई भी प्रॉब्लम हो तो I'm here, right? Thank you everybody. Take care.